All right, the next case to come before the court is State versus Graham. Both sides ready to proceed?
Yes, Your Honor.
Since you two are old hats at this, you know you have 15 minutes, and you can reserve up to 5 as the appellant. And we're ready to proceed.
May it please the court, my name is Attorney Joseph Salzgeber on behalf of the defendant appellant Heather Graham. I'd like to reserve the balance of my time, approximately 5 minutes for rebuttal.
That's fine. Thank you.
This case involved the tragic heroin overdose death of a Miss Brittany Johns back on May 29th or 30th of 2013, and the state's efforts to successfully charge and blame Heather Graham for supplying the heroin. That contention by the state was false, and unfortunately Heather Graham was erroneously convicted of 3 separate offenses: corrupting another with drugs, complicity to trafficking in drugs, and conspiracy to trafficking in drugs, and sentenced to 3 years in prison. With respect to all 3 charges, our assignment of error is that the evidence was insufficient to support the trial court's verdict of guilty as to all 3 counts, in particular the corrupting another with drugs count, and that the conviction as to those 3 counts were also against the manifest weight of the evidence. With respect in particular to corrupting another with drugs, the key issue with respect to this felony of the 2nd degree was whether or not Heather Graham knew or was reckless in knowing whether or not Brittany was a juvenile. I think there's no question that Brittany was a juvenile based on her mother's own testimony that she was born on November 5th, 1995, so she would have been approximately 5.5 months shy of her 18th birthday. However, the question at trial was whether the offender, in this case Heather, knew the age of Brittany or was reckless in that regard. The state presented no evidence to support the contention that Heather Graham knew the age of Brittany or was reckless in that regard. Darlene Johns, the mother who testified as to age, never met or ever spoke with Heather. And I should back up just a little bit. Heather Graham and Brittany met at Narcotics Anonymous meetings here in Medina County. Heather had recently moved here from Virginia at the urging of her father and was living with her father and stepmother in Medina in order to get off of heroin. She had been an addict. She had become addicted, first to pain pills after suffering severe injuries from an IED explosion while serving in Iraq. When she was abruptly cut off from the pain pills that she was taking in 2010, as many addicts do to pills, heroin became the substitute, and her life declined precipitously due to her heroin use. Prior to that time, she had some very impressive jobs in security. She was even on a details protecting the President of the United States, the Vice President, and the Attorney General. Nonetheless, by the spring of 2013, she was unemployed on heroin, and her father urged her to come back. She had hit a car crash, so she had even no vehicle at that point. She arrives here in Medina in May, goes to the VA hospital in Cleveland in an attempt to get clean and get into their heroin program for women. She is prescribed a drug that inhibits opiates in order to help her cope with her addiction. She's taking drug tests there, which are all negative from the time she first goes there in mid-May of 2013 through late June of 2013, encompassing this entire period when the alleged criminal activity took place. She's attending Narcotics Anonymous meetings in Medina, and because Medina is not a large county like Cuyahoga or Summit, you only have 2 locations in the city of Medina, a church just south of here and Cubs Cafe, which is within walking distance of the square, just north of the square. They meet one another in the latter half of May. Heather Graham and Brittany arranged to meet one another after meeting on May 28th. They start texting one another for the first time and become friendly. Because it's such a small community and the people who are attending Narcotics Anonymous meetings get to know one another. They spend the day together, but unfortunately, Brittany, who's recently out of rehab herself after 30 days, I believe she was in residential rehab. She's home for 30 days here in Medina, living with her mother and her mother's boyfriend. She's actively seeking to get heroin that day. She has her brother Mark Johns is on heroin. Her brother's girlfriend Sammy Liptag is on heroin. She had been in contact with them via email and texting the morning before she was to meet with Heather Graham to spend the day together. From the communications then that came out in trial, Sammy Liptag had apparently located a drug dealer who was willing to sell heroin for $140. Brittany said she would give her more money if she needed it to get heroin, and they were going to meet sometime later that day of May 29th, 2013. She's subsequently in contact with Heather Graham's alleged co-defendant, Jason Gangle, about getting heroin as well. She texted him after scoring heroin from Sammy Liptag, or arranging to score heroin from Sammy Liptag. She says to Gangle via text, "Don't worry, my dude already has gotten me some heroin." So she had multiple people, Jason Gangle, Sammy Liptag. There was also someone else, a Shane McNamore, who was the former boyfriend of Brittany's John's mother, Darlene Johns. She had broken up with that boyfriend because he was on heroin. So unfortunately, Brittany was in a situation where she was surrounded by heroin users. Her own family had heroin users. Her friends were heroin users. And she was actively seeking to obtain heroin that day. Unfortunately, Heather Graham walked into this situation not knowing what was going on. She had arranged to be with Brittany that day. They drove all over Medina County shopping at various places. People who bumped into them, such as Heather Graham's stepmom, thought that Brittany looked to be about 23, a college-age young woman. Her own grandmother bumped into the two of them during their exploits that day. I believe it was at Walmart, and neither of them appeared to be using drugs at that time. They did travel up to Cleveland, however, so that Heather Graham could determine whether she could get bus transportation from Medina up to do her rehab program up at the Cleveland Veterans Hospital located in University Circle there near Case Western Reserve. But in none of the testimony did anyone ever indicate that Heather Graham knew Brittany Johns was under the age of 18 or otherwise reckless in that regard. Both Heather and her mother testified, her stepmother testified, that Brittany appeared to be in her early 20s, perhaps age 23. The only inquiry that was made was when Heather texted Brittany, "Do you go to school? We should go out and eat or something tomorrow. It's on me, I'm tired of sitting around the house all day." Brittany's response, which was admitted at trial, she texted back, "No, I graduated, but I don't work tomorrow, we should." So in this instance, we have someone who's graduated from school. Heather believed it was college, but it was apparently high school, and so she didn't know that it was a high school graduate rather than a college graduate. Brittany works, she has a job, she has a driver's license. And frankly, when you're 18, most graduates of high school are 18. So even if there was some mistake on Heather's part, and it was high school rather than college, most high school graduates are 18 by May or June when they graduate. Heather's stepmother, who was familiar and had volunteered with 17 and 18-year-olds, had the opportunity to see Brittany that day when she stopped by Heather's uncle's home here in Medina. She thought that she being Brittany, was early 20s and had graduated from college. She certainly didn't look to be someone who was 17 and only a few days or weeks out of high school. Viewing the evidence in a light most favorable to the prosecution, The state failed to prove that essential element of the charged offense, felony 2, corrupting another with drugs, because there was no evidence that Heather Graham knew Brittany Johns was under the age of 18 or was otherwise reckless in that regard. So we would ask the court to reverse the corrupting another with drugs conviction based on that, and even assuming arguendo that the evidence presented at trial concerning that essential element of age was somehow minimally sufficient, an independent reweighing of the same evidence would demonstrate that that evidence weighs heavily against the conviction, because there's simply no testimony by anyone that Heather Graham knew or was reckless with regard to Brittany's age. With regard to all of the offenses, the state further failed to establish the element that Heather knowingly furnished or administered heroin to Brittany Johns, purposely planned or aided in planning a trafficking and heroin offense, or knowingly aided and abetted another in committing a trafficking and heroin offense. Heather's testimony at trial was that they had driven up to the Cleveland Veterans Administration so she could find out whether or not she could get transportation by bus or van or otherwise from Medina County up to the Veterans Administration for her counseling and treatment for heroin addiction.
Was the testimony that the car was rented for that purpose?
Yes. Heather's car had been totaled in Virginia before she even came here.
Was the testimony also that it was for the purpose to determine this to get up there the following morning, or was it just a general inquiry? What is the testimony?
The testimony with regard to the car was that Heather Graham did not have a car. She wanted to
get to Cleveland. The testimony was she was going to go up there to see if she could get a ride.
But she was going to arrange future transportation, or trying to find out if she could arrange future transportation from Medina up to the VA hospital. And that was due to the fact that her stepmother and father both worked, and they would not be available consistently to transport her up there, particularly during the daytime. So she was trying, they had taken her up twice already to set up the program, but it was not something that they could consistently do given the fact that the father occasionally worked out of town, out of state, and the mother had to go to work earlier than she could arrange to transport her up and back, her being Heather, to the VA hospital.
Did I read somewhere that she asked Brittany to do the driving because she didn't have a driver's license?
She had a military ID, which would allow her to rent the vehicle, but she had not yet gotten an Ohio driver's license in the state of Ohio.
But not to drive the vehicle? She could rent the vehicle but not drive the vehicle?
Yeah, they allowed her to rent the vehicle based on the military ID and the fact that she had a credit card.
Counsel, you are down to like 2.5 minutes. It's up to you.
Essentially what we have here was someone who Brittany was actively attempting to get drugs that day, heroin. She had multiple sources. She had already secured a source of drugs from Sammy Liptag and was arranging to meet Sammy and her brother that evening. She had Jason Gangle, who admittedly purchased the drugs in this case. The only real issue was Heather with them when they did it, or was she, as she claimed, at the Cleveland VA hospital waiting for 20 or 30 minutes to get the information she needed. And so in this respect, everything sort of hinges on Jason Gangle's credibility, and we're dealing with someone here who had already had a burglary felony conviction. He had 2 pending theft convictions that were awaiting resolution when he testified at trial. He testified that he purchased the heroin in this case. He was contacted earlier that morning before Brittany even arranged this day-long adventure with Heather about obtaining drugs, Brittany obtaining drugs from him. And he changed his story so that he could testify and help the state. He originally said, I didn't do drugs or buy drugs at all that day, but they needed him to testify because there was no heroin found.
And you're down to a minute.
And they needed him to testify because they needed someone who could testify that it was in fact heroin. So if he maintains, as he did originally, that, hey, I didn't use heroin that day, then the state has nothing with respect to what the substance was that Heather Graham took that day. There's no corpus delicti, if you will, because the heroin did not exist to be tested. So him changing his story was really a key here. He avoided dealing with the police. He avoided, unlike Heather Graham, who cooperated with the police in this instance, he just avoided them for weeks until he got his story straight. And then he changed his story. He couldn't even identify the drug dealer. That kept on changing.
And counsel, you're out of time.
Thank you. I would ask that this court sustain the assignments of error and reverse with respect to all three convictions in this case. Thank you.
Thank you.
Thank you, Your Honors. May it please the court, my name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. As I understand the counsel's argument this morning, there is one assignment of error which states really two claims. The first is obviously sufficiency, and the second is manifest weight. And they have two subclaims within that. And the first is whether Heather Graham gave the minor in this case heroin, and the second is whether Heather Graham knew that the minor was under the age of 18 or was reckless in that regard. And I guess I'll start with the did she give the minor heroin question first. The argument this morning and in brief by the defendant is that her testimony established that she did not provide heroin to the minor, period. The testimony ignores or largely fails to account for the trial court's ability to observe Gangel's testimony at trial and to observe the other evidence which was adduced at trial, establishing that Heather Graham was the one and only person who could have possibly given heroin to the minor in this case. There's no dispute in this case that the minor died as the result of a heroin overdose. There's no dispute about that. The dispute is whether Heather Graham is the one who gave it to her. Facts established at trial by the detective from the Medina City Police Department showed that an extensive search of the minor's room, surrounding area, basically the entire house where the minor lived, there were no drug paraphernalia. There were no spoons, there were no needles, there was no residue. There was a mark in between her toes when he examined the body at the hospital where she was taken after she was eventually pronounced dead. And that was the only thing he could find was connecting it to drug issue at the time. So there's no drugs in the house. There's no needles in the house. There's no spoons. Clearly, someone had to provide her the heroin. The only person, even by the defendant's own testimony, the only person with the minor at a time when she could have ingested the heroin to eventually then be found unresponsive by her mother at 5 o'clock in the morning was Heather Graham. Gangel had left them hours before. If he had given Brittany, if he had given the minor the heroin at the time when he last saw her, she would have died hours before. Right? The fatal dose would have occurred much sooner. Heather Graham is the only person who could have provided the heroin to the minor in this case for the facts to occur as they are undisputed. Because of that, the trial court did not err and the state presented sufficient evidence for Heather Graham to be convicted of corrupting a minor with drugs. Which is to say nothing of Gangel's testimony, in which he goes through the timeline of the events, which matches up with other evidence in this case. Specifically, his testimony is corroborated by text messages, which confirm his conversation with the minor. Cell phone extracts showed that after he purchased heroin from the street dealer, which he admitted to at trial, after having already pled in his case, he said, "Let me know if you need me to get any more stuff for your friend." And then he identified Heather Graham at trial as the friend with whom he had purchased heroin.
And this was a text message?
Yes.
On his phone?
On the minor's phone.
Right.
Received from Gangel. So,
Why would he text the victim, hey, are you okay, if she had never ingested any heroin to his knowledge?
because clearly he knew she was going to. I think there's testimony in the record that he knew the minor from previous meetings. They kind of all had met in Narcotics Anonymous meetings in Medina, which there's another point there about testimony about the middle school age of some of the people who attend these meetings, which is obviously regrettable, but it does establish the knowledge or recklessness aspect, but I'll circle back to that around in a second. The issue with Gangle texting the minor, in this case, asking if she was okay, is because when they purchased the heroin, he actually, according to his testimony, which the trial court believed, at least part, according to his testimony, he prevented the minor from ingesting the heroin while they were stopped at the gas station in Cleveland because he was concerned she had been in treatment and he was concerned that she was too much for her potential tolerance. He was concerned about her overdosing. So he actually did not allow her to ingest at the gas station when he and the defendant did, according to his testimony. So, knowing that she intends to ingest and knowing that he's now left her and that Heather Graham is the only one with her, is following up saying, hey, are you okay? Now, the other reason why Gangle would be interested in following up and in trying to establish a future meeting is because, as he testified, he gets a benefit from arranging these transactions. He got an additional $20 plus part of the heroin he purchased. He was out no money. He got $20, and he got part of the heroin that he scored from his dealer in Cleveland because, I guess in a way, he had the quote hookup, right? He gets a benefit from arranging this transaction. That's why he's calling to come back and say, please, let me know if I can be of any further assistance. Now, the other issue in this case is whether Ms. Graham knew or was reckless in the regard of the victim in this case being a minor. And there's, contrary to counsel's argument, there is a wealth of evidence in this case that she either knew or was reckless with respect to that fact. The first, which is according to Ms. Graham's own testimony, is the facts from the cab ride. After returning the rental car, they called Advantage Cab, and Mr. Kirstein, the driver of the cab, picked them up from the rental car agency and drove them back first to the minor's house and then drove Heather Graham back to her house. On the ride to the minor's house, they were all talking. They knew each other from substance abuse meetings. He had himself said that I'm a recovering addict and I've been under control. This is the job I do. During that ride, they're all talking. Heather Graham is in the front seat smoking a cigarette. But then, according to text message logs from the victim's phone, she asks Heather Graham for, quote, some shit. And it's clear from the context that that's a reference to heroin, the state believes. In response, after not receiving a response for a few minutes, the minor follows up with two question marks, prompting Heather Graham, who is sitting 4 or 5 feet away from her, front passenger seat to middle seat of the van, 4 or 5 feet away, to respond with a text message rather than turning around and saying, what do you want? She responds with a text message saying, how exactly do you want me to do that? Do you want me to pull it out in front of him? Now, if the shit, and I apologize for the language, but that's what we have in this text message. If that stuff is a cigarette, as Ms. Graham tried to claim at trial, why was she so worried about hiding that from the cab driver who's allowing her to smoke in the front passenger seat? No, it's because she thinks either it's actually heroin, and she knows it's heroin, and she's going to be providing it to Ms. Graham, or if you believe Ms. Graham's story, that it's really a cigarette, it proves that she knew that the minor was under the age of 18, because cigarettes are only illegal for minors. So, either it is heroin and she knows she's giving it to, or she's clearly aware or reckless with respect to the fact that she's going to be providing it to a minor. This is her own testimony. The other issue is the Narcotics Anonymous meetings that witnesses, and I think Ms. Graham specifically testified that she knew that some of the people who attended these meetings were middle schoolers. Clearly, that at least puts her on some kind of notice that, hey, these people are pretty young. The third fact we've argued on a brief, and I'll refer to today, is in the text message conversation, she asks, or there's reference to the fact that the minor is graduating. right? The college graduations occur much earlier, the early to middle part of May. This is the later part of May. And there's conversation about whether the minor has graduated yet. Now, if you're concerned that maybe that's high school, maybe that's college, and that's not necessarily as informative, put that in context with the testimony of the minor's grandmother, who the defendant, the minor, ran into at Walmart that day. Ms. McTook testified that she saw Ms. Graham and the minor, that Ms. Graham appeared with her eyes were very red and they seemed unfocused, consistent with drug use. And Heather Graham tells Ms. McTook that she thinks that she's very young, that she looks like she's only 40 years old. How are you possibly this girl's grandmother? In response, Ms. McTook testifies that she tells Ms. Graham the age of the minor's mother. So there is clear evidence from this record that Heather Graham either knew that the minor was a minor or was reckless with respect to that fact. Now, there's a little bit of some kind of argument about Gangle's credibility. He appeared in court. The judge, who was sitting as the trier of fact in the bench trial, had an opportunity to observe his testimony. And from the record, we see that he's rather frank with respect to his role in the offense. He doesn't try to conceal or cover up the full extent of his involvement. He says, yes, I arranged a heroin transaction with my dealer in Cleveland. He gives a somewhat detailed description of where that happened, how it occurred, and who the dealer was to the best of his recollection. Now, obviously, he's not interested in giving up like a name and critical description, but it's also been some time. Now, the other fact that the trial court had as a credibility issue in this case was Heather Graham said that when she was dropped off at the VA hospital in Cleveland, that Gangle and the minor left, and that's when they did their transaction. The timing doesn't quite work out. When Heather Graham went into the hospital, allegedly, she's doing so to figure out if she can arrange a shuttle or some kind of transport to the VA from Medina. She could have called. There's extensive testimony about this fact, that yes, the VA has such a program, yes, the VA operates a shuttle, yes, she could have called and found that out. She doesn't go for an appointment. She goes to the information desk, according to her testimony. That would have taken maybe 5 minutes from being dropped off, walking in, asking the question, and leaving. She didn't say that she was waiting for Gangle and the minor to come back from purchasing the drugs. They're up at, Gangle says it's at St. Clair and East 123rd Street. That is more than a 5-minute drive from the Veterans Administration Hospital in Cleveland. Her story doesn't match up. It's not credible. Compared to the consistent, detailed testimony of Gangle, who has already testified that yes, when I was first interviewed by police, I was less than forthcoming for obvious reasons. But here's what I did. Here's my role of the offense. Versus Heather Graham, whose story is inconsistent within itself and doesn't match up with other uncontested facts in this case. Against that.
Gangle testified that he observed Graham ingesting heroin.
Yes.
So what are we to make of the subsequent negative screen following on it?
Well, I think that fact was explored in some depth at trial, and it's worth noting that that was an unmonitored screen, that no one watched her give the sample. When she was placed into the intensive treatment program at the VA months later, when she was being monitored, she started testing positive. Also, no one testified that she was experiencing any kind of symptoms of withdrawal. Right? If you are a heroin user and you suddenly stop using for a period of time, there would be noticeable symptoms of withdrawal. No one testified that she experienced those symptoms. In fact, Heather Graham testifies that she's aware of what those symptoms are and that they are, I think her phrase was, unpleasant. She never says she was experiencing that. No one says they saw her experiencing that. So I think the conclusion to draw from all of those facts, the inference clearly is she was still using. She used. The fact that she did not test positive the following day, I think is of little import. I think it's not unheard of and actually fairly common for people to not submit their own urine.
Did Gamble testify as to the method of ingestion of heroin?
I believe he says that it was with a spoon and then injected using a needle, I believe is his
No
testimony.
testimony or oral ingestion?
I don't believe so, no. Which is consistent with the mark found in on the minor's foot by the detective at the hospital. And again, I point out the absence of any spoons, tourniquets, needles, or other drug paraphernalia found in the minor's bedroom or even in the house anywhere. So clearly she did not inject herself and then go to sleep and overdose. Someone injected her, which is why the state pursued and was successful in obtaining charges for corrupting a minor with drugs. It was furnished or administered to her by another. That person in this case is
Counsel,
Heather.
you're out of time.
Thank you. I respectfully ask the court to affirm.
Gentlemen, thank you both for the presentations you made to the court today. The court will take the matter under advisement and issue a written opinion that was sent to both sides as well as released on our website. Thank you.